Good day, Crime Talk aficionados. This is Scott Reisch from Crime Talk. Today, a big thank you is in order. The detectives in the Kelsey Berreth case go digging. Christopher Watts continues his silence and reaction to a video about a case that I did some 15 years ago that was on primetime TV, and yet everybody's upset. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch from Crime Talk. And the first thing on the docket today is thanking you. ScottReisch.com, Crime Talk, has had a huge response from the YouTube world. We would like to thank you. We have over 35,000 subscribers in a rather short amount of time, and the numbers continue to grow. We here at Crime Talk could not have done that without you, and we thank you. We will continue to try and bring you information and a perspective that you are not going to see on the evening news, and frankly, a whole lot of speculation into a bunch of tin hat conspiracy world type of things. We want to talk about facts. We want to talk about reality and what's really taking place. So thank you, thank you, thank you. If you like the channel, and you haven't subscribed, please subscribe. If you like the video, hit like. And if you'd like to be notified of when we go live or when a new video comes out, hit that little bell. We would appreciate it. The next case on the docket today is that sources have confirmed that Waste Management Wednesday night confirmed that authorities are turning their attention to a landfill in Fountain, Colorado. And the communications director for Waste Management provided a statement to the news, basically stating that Waste Management is assisting in any way and they will continue to cooperate fully. There's been no news of the actual search as to what was taken, what exactly they were looking for, and ultimately if anything was found. Now, I've mentioned in this particular case, the Kelsey Berreth disappearance case, the murder case, and Mr. Frazee is accused of killing his former girlfriend, mother of his child. And I have said that the case has some difficulties as it relates to the prosecution because they don't have a body yet, and because we have not seen the affidavit for arrest warrant or the discovery in this case, we don't know exactly what they have. But it seems to be that they are still looking for the body. Some people say you don't need a body to prove a case. I totally agree. It just makes it a lot easier. And obviously, they want to find Miss Berreth, not only for her family, to make sure that she receives appropriate burial that she deserves and anyone would be entitled to, but it's going to help them make their case. So for whatever reason, they were looking in the landfill, whether it was for cell phones, whether it was for Miss Berreth, perhaps, any evidence of the crime, they're looking. So the search continues. So that is the significance and breaking news. That happened a couple of days ago, and nothing's come from it. So I don't think they found anything of great import, but we will have to wait and see. The next case on the docket is the Christopher Watts case, the case that just seems to not want to go away, and the case that people are still very interested in. And today we're talking about the civil case. And as many of you know, Mr. Watts obviously had pled guilty. And on November 19th of 2018, Shanann Watts' estate and her parents sued Christopher Watts in Weld County District Court. And they filed a wrongful death action as it relates to their daughter and the grandchildren. And what takes place is that once a complaint is filed, the complaint has to be served upon the defendant, and they usually have 21, 28, 35 days, depending on when they were served, if they're out of state, and what have you. And the court issued an order the other day, on January 7th to be exact, stating that the complaint was filed on November 19th. No answer has been filed by Mr. Watts. Did we expect him to do so? No, not really. Because if he was going to participate in that proceeding, he could be deposed. He would have to give truthful answers under oath, and we know he doesn't want to do that, okay? And this case was brought because they didn't want Mr. Watts to profit from the case in any way, and to make sure that if he were to receive money on his books from individuals out there who are his fans or anything along those lines, people sending money on his books to make his life more comfortable, that they would be able to get a portion of that in form of garnishment. But the interesting thing is obviously Mr. Watts hasn't filed a response. At that point, the court is expecting things to happen. The plaintiff has a duty to prosecute the case. And at that point, there's a default judgment should be entered. And the court states in their case management order that a default judgment has to be filed 21 days after the default has occurred. So 21 days after the answer would have been due, or if there was an extension, something along those lines. So the court issued an order basically saying, hey, plaintiff, you have 35 days from the date of this order to file a motion for default judgment and move this case along, or advise the court what action may be appropriate, why we shouldn't dismiss this case, because we're not going to let it linger around on the books. You got to get moving, or I'm going to dismiss this case. And then you have to decide you're going to bring it again, or you're going to be barred from bringing it again. So Shanann's parents need to do something here, and they need to do something quick, or the case is going to be dismissed. But not surprisingly, Mr. Watts did not respond. So did we think he was going to? I didn't think so. All right. Now, third thing on the docket today is reaction to a video about a video that I posted. Okay. God, 15 years ago. Okay. 15 years ago, I did the Lord Trujillo case. It was just a routine case. It was a case where the court asked me to represent somebody at state expense. Okay. I assure you, state expense doesn't come anywhere near my private fees. But I still do take very serious cases at state expense because I believe that everyone is entitled to a defense under the Constitution. Okay? Simple. I am not going to apologize for doing my job as a lawyer and defending anyone's constitutional rights. Okay? And the thing that was interesting about the case of Laura Trujillo was that here in Colorado, and I believe another state, Ohio, at the particular time, ABC had received permission from the Supreme Court in each of the respective states to follow appropriate cases where all parties basically agreed to have the cameras follow them. So you had the prosecution preparing for the prosecution of the case, the defense attorneys preparing for the defense of the case, you had the trial, and then most importantly, you had the jury deliberations. It was something that had never, ever been done, and I am not aware of it ever being done even again to this day, all right? And as you can see, the significance why I put this case up, and I said, did Watts stand a chance? If you watch the video, it wasn't I'm trying to say, oh, look at me 15 years ago. That's ancient history, okay? And what had happened in that particular case is that it shows the dynamics of a jury. It shows that you get people from different walks of life with different perspectives, different realities as to what they bring to that jury room, okay? No juror shows up with in a vacuum and says, throw out all your life experiences completely. And you may have one person who was raised in, the perfect family, mother was perfect, everything's perfect, no one's ever done anything wrong. And then you may have other people, and their reality is you know what? I've dealt with this kind of stuff, and this is the way people think where I grew up, and this is how things are done, and this is the way it actually happened. And those are the things that jurors can consider. And one of the instructions they get when they're a juror, it says that you can believe some part or all of the evidence in the case from the witness. And in this particular case that we showed, You have to remember, we had almost a year of preparation from the time the case started, from the case went to trial, and they whittled that down into roughly 40 minutes, okay? And so when they show one question whereby I asked Randy if he was in fact the one who killed Alizé, they said yes. But it didn't show the other 3.5 hours where his story that my client didn't know anything about it and that she was asleep because she was on pain pills because she had been shot recently, and the facts suggested that he's the one that had done it. And when she takes those pain pills, she's completely out of it. Okay, that the murder, not just because somebody flicked a child, which is not appropriate. Okay, not good parenting skills. Let's face it. You don't flick children. You don't flick their ears. You don't flick them until they cause bruises. And that's really what the jury found her guilty of. It was a compromised verdict. Some people wanted her to fry. Other people said, hey, there's an in-between here, and they compromised. That was the point of the video, ladies and gentlemen. You get 12 people from different walks of life with different realities, different perspectives, different way they perceive the evidence coming in. You can get a different result. It is not always a slam dunk for the prosecution, and it's never a slam dunk for the defense, okay? I have won trials I should have lost because of the jury, okay? I have lost trials that I thought that I should have won. I can think of one rather recently where I'm still sitting here scratching my head as to what the hell happened. Everyone in the courtroom, the most shocked people in the courtroom were the district attorneys. They thought that they had lost. They literally thought they had lost. Maybe a not guilty, at most criminally negligent homicide, and the jury came back second-degree murder. You just never know. And in that particular case, jurors didn't want to speak with us. Okay, that's fine. I still think in that particular case, they went and Googled my client and saw that he had some history, which goes completely against what jurors are supposed to do. They're supposed to make their decision based upon the evidence that is presented in courtroom, legal and competent evidence, not what you hear on the news or some guy speculating about what could have happened or this shadow looks like this on YouTube. Okay, we're talking about real facts. When people do that, it's not a fair system. All right. So in some of those comments that in regards to that case, I received many, and to summarize them, I will do this. There were a few. Wow, Scott, great job. Most were, your client is scum. Okay, she is guilty. How can you live with yourself? How can you represent those people? Okay, now understand. Now, if one becomes an attorney, and there's lots of different attorneys, you can say, I want to be an attorney and go do corporate law. And in all honesty, that's what I thought I was going to do when I was in law school. I was working for a firm that did corporate transactional work and civil litigation, and that's what I thought I was going to do. All right? And then you sit there and you struggle. Should we put the comma or the semicolon in? There's actual litigation on the meaning of the comma and semicolon and the word and or, etc. in contracts. I realized that is not what I wanted to do. Okay? So after law school, I went back on active duty and I was a judge advocate. And it was great. In a million years, I never thought I was going to do litigation. But I showed up at my first duty station. I was a prosecutor. I was a defense attorney. I did whatever we call it. We did wills for people. We did all those types of things. It was fun. And it was challenging. It was interesting. And I found my niche. And I should have known better because really my best class in law school was trial practice, getting up and talking about cases and talking to people. That's what I should have done. I should have known better, but it took me going through that process, okay? So a lot of people make those types of decisions. What type of law? But a good lawyer and any lawyer should be able to pick up and argue any side. Now, most people have the luxury and say, oh, you can't do that. When I was a prosecutor, I showed up, or when I was in the Marine Corps, I showed up and the colonel was like, all right, you're going to be a prosecutor. And my friend, he's going to be a defense attorney and vice versa. We're going to switch. So you got to do both sides of it. And that's what a good attorney should be able to do. argue all sides of it and look at it objectively and come to a conclusion. It's kind of like when they teach you when you're becoming an officer, leader of Marines. Your job is to remove yourself from the emotion of the battle so that you can make good judgments and look at the facts for what they are. And that's what attorneys are supposed to do. And a lot of these comments are simply, oh, a child is dead. You're scum. It's a tragedy, okay? When a child dies, the community loses something. It is a horrific thing. I'm not trying to condone it. Anytime I've ever defended anybody charged with a homicide or a child abuse resulting in death case, this is not a referendum on whether dead children is a good thing. It's a bad thing, okay? The question is did somebody do it? Did somebody else do it? Was it natural causes, or was there an exacerbation of a medical condition, or was it in fact simply murder? And that's what the facts are. That's what we try to do. And attorneys try to look at that objectively. And some people, I had people that said, I'm not subscribing to you anymore, or I'm not going to subscribe to you because you represented that horrible word, that person. Okay? That's fine. That's okay. As a criminal defense attorney, we represent our client. We do. We're going to do it to the best of our legal and ethical ability. And if you can't do that ethically, you tell somebody, you know what, I'm not the attorney for you. You may want to hire somebody. I know people that are attorneys that have had children that have gone through addiction issues, and they simply cannot represent someone that's accused of selling drugs because it has affected them so deeply that they cannot zealously represent that person. And at least they do that, okay? But as a lawyer, your job is supposed to do that. Of course, I need you to represent this person. You're supposed to say, I should be able to do it, and put your emotions aside to do it. Do I think anyone I've ever represented for a homicide or a dead baby case I somehow think that was a good thing? No, absolutely not. It's not about saying the act was a good thing or a bad thing. It's simply, did it happen? Did the person do it? And sometimes you plead guilty because it happened. And sometimes they're bad. They made a horrible mistake and they're going to live with it forever. When somebody fills the bathtub and they don't realize that the kid climbs in and he drowns, do they intend to do that? Or are they just a really bad parent that particular day and they got overwhelmed by the circumstances? And they will live for that forever, okay? And what most people don't understand is that can happen to anyone. Everyone sits in their high and mighty little horse and says, I'll never get in trouble. I've never done anything wrong. Guess what? Who hires me more than anybody? Parents and grandparents for their kids and their grandkids. Because everybody knows that people make mistakes. Okay? Sometimes it's horrible mistakes. But if it's your loved one, you're going to come and hire me. That's what you're going to do. You're going to look for the best, most experienced attorney who's handled these types of situations. And you're going to do that because it's your loved one. And whether they did it or not, you're still going to make sure that they have the best legal representation. So at the end of the day, and whether it is plead guilty and go to prison, at least you knew what you did was the right thing. You've looked at all the legal obligations, the defenses, anything that had to be done. Okay? So as a criminal defense attorney, we don't necessarily agree with what the defendant is accused of doing. We're not saying, hey, it's a good thing, it's a bad thing. We're representing them. We're representing the Constitution. Okay? And that legal document protects all of us. Okay? If a defense attorney didn't challenge things, people wouldn't have the rights that they have. Okay? And let's just break out the handy-dandy pocket Constitution that we carry with us just about everywhere that we go and look at the Sixth Amendment. Remember, the Sixth Amendment, the first 10, the Bill of Rights, the colonies wouldn't sign the Constitution unless the Bill of Rights were there. Amendment 6, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Speedy trial means we're not going to let you sit in the stockades and linger. Public trial means it's open to the public and everyone should come and see it or be able to see it. We're not going to do it in a back room where it's, some communist country or something like that, okay? By an impartial jury, okay? We want a fair and impartial jury. If we had a bunch of people that said, just given the nature of the charge, I could not be fair to you, guess what? I thank you for letting me know, but you're not going to sit on that jury because you cannot be fair and impartial, all right? And of the states and district wherein the crime shall have been committed. So if you're committed the crime in Colorado, you're going to be tried in Colorado. You're not going to be hauled off to Maine and be tried there. Because guess what? You may have different kind of local standards of what's right or wrong than here. It's just, that's the way you're just going to do. Your witnesses are there. Your family's there. It's going to be done in the district in which it was found. Which district shall have been previously ascertained by law, and to be informed of the nature of the cause of the accusation, to be informed of the charges. The charges have to be specifically stated as to what you did wrong, all right? To be confronted with the witnesses against him, which means you actually have to have witnesses come to court and you can cross-examine them, all right? The confrontation clause. You have a right to confront your accusers. You have a right to actually have witnesses come. It's not going to be 10 people down saying, ooh, I heard somebody did something bad in their house and go get them. All right? That'd be crazy. These are all the things that the founding fathers wanted because this is the thing that the king did. They knew, they looked at all the history, okay, and they said, what have all the tyrants in the world done? And why have they done it? And we're going to put it in the Bill of Rights, the first 10 amendments, and say, we're going to have something radical. We're going to have a jury system, okay? And that's the Sixth Amendment. And so that's important. So you have a right to know the charges against you. You have the right to compulsory process for obtaining witnesses in his favor and to have the assistance of counsel for his defense. Compulsory process, being able to subpoena documents, being able to subpoena witnesses to come to testify on your behalf. What good is it if you have a witness who is an eyewitness, but the prosecution says, well, we're not going to bring them. You can't have them, okay? That wouldn't be fair. But these are all the things that the founding fathers said you get a right to. And what does it say? And to have the assistance of counsel for his defense. Bam. It's constitutional right. Constitutional right. And some people, I've had clients say, listen, man, I'm guilty. I did it. And I'm saying, it's a simple case, little DUI. This is what's going to happen, A, B, C, D. I can tell you right, you're in front of this judge and this is the way it's going to be. And you know what they say? No. I get so terrified of public speaking, to standing up there. I'll pay you your fee. Just, I want somebody there by my side. I want somebody there just to be there with me in case I get nervous. So I say something wrong or I do something wrong. And how do I know if it's a good deal or not a good deal? All right. And so simple and straightforward. So Sixth Amendment, right to a jury trial, right to defense counsel. The Fifth Amendment, no person shall be held to answer for a capital or otherwise infamous crime, unless on presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So, a couple things there in the Fifth Amendment, right? You have a right to have an indictment presented. Obviously, in federal court, you get an indictment. Some states do indictments. Most do complaint and information, but it can also be indictments. And unless it's time of war, et cetera, it doesn't really matter. Can't be put in double jeopardy twice, which means if you've been found not guilty, they can't come back and charge you with the same offense again. Nor can you be deprived of due process of law. Okay, once again, constitutional right, founding fathers, pretty smart people, okay? So a lot of these people that said, shoot them, kill them, I can't believe we're wasting our money on them. Due process clause, ladies and gentlemen. It's called the process. You have to go through the process. You have to give them a fair trial. You have to let them see the evidence before them. We're not making this up. We're not making it difficult. It's constitutional rights. The founding fathers said, all the tyrants in the world, these are all the things they don't give us. And since we're starting this new country anew, we're going to write this thing out and we're going to write it so that it's fair to everyone. And you may not like it all the time, but if it affects you or a loved one or a family member, you're going to thank yourself. You're going to thank the founding fathers for that. Okay? You have right to appeal a case, bond. Those are all things. If you love your First Amendment rights, ladies and gentlemen, when the legislatures go out there and pass laws saying it's illegal to do a particular thing or say a particular thing, somebody actually got charged with that. And some heinous criminal defense attorney said, no, you can't do that. That's a violation of our First Amendment rights, okay? So think about it. I know people don't like defense attorneys. How can you represent those horrible people? I get it, okay? Was it what I thought I'd ever do in my life? No, but that's the reality of it, okay? Could you imagine if somebody put up a crime, made it a crime to, you couldn't post negative comments in YouTube land. That would be a criminal offense. You'd say, hey, what? I should be able to say if I like this video or I thought it sucked. This guy sucks. But someone says, no, you can't do it. All the YouTube people went to the legislature and said, we like it. We don't like to be criticized. We don't like people being mean to us. They passed a law because the legislature says, we don't like people being mean to us either. So maybe we should pass a law saying you can't criticize your elected officials, okay? Someone's going to do that. Someone's going to challenge it. It's going to be a criminal defense attorney protecting that. And by way of protecting that one person that everybody thinks is heinous or is a real jerk or saying something nobody likes, it's actually protecting each and every one of you. Do you like your privacy? Do you like your privacy? Okay? The Fourth Amendment of the Constitution, okay? The Fourth Amendment to the Constitution says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizure shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularity describing the place to be searched and the person or things to be seized. Okay? You like your privacy? You like the fact that the police can't just come and kick in your door and say, we think you've done something illegal. We're just going to take a look around till we find something here. Okay? That's because of the Fourth Amendment. Do you like the fact that if you got pulled over for a speeding ticket, the cops couldn't say, hand me your phone, let me take a look through it and see if you've been doing something else illegal on here? That's because of the Fourth Amendment. And more importantly, why is that there? It's because of recent Supreme Court cases and criminal cases where a defendant says, hey, you can't search that phone without my permission. That is private information of my property. And you can't go in there without a warrant. And you have to know exactly what the hell you're looking for. You don't get to go rummage around because that's a general warrant and that's illegal. Well, guess what, ladies and gentlemen? The Supreme Court ruled that way last session. And now it's law. That's the law of the land. It's illegal, unconstitutional for the police to take your phone, put it in front of your face, unlock it, make you force you to tell the screen code, and so they can start to go searching through it for criminal activity. And who knows, maybe you're one of those people who says, I have nothing to hide, therefore, what should I have to worry about? Well, what if you have something on there that you may not thought was a crime, that wasn't illegal? Bet you'd like that phone not to be searched at that point, wouldn't you? Maybe somebody sent you a document an attachment to an email you didn't know and it had something weird or nefarious on it. Yeah. So if you like your privacy, thank a criminal defense attorney. All right. You like witnesses to appear in court because we don't proceed by paper and affidavits. Okay. We get the subjective cross-examination, which is the greatest truth-seeking tool ever invented. Okay. It's the confrontation clause. But over the years, the state started getting more and more away from that and saying, well, we don't need a witness. We'll just bring in these other people 2 or 3 hours later to talk to somebody good enough, it's reliable. Guess what? Supreme Court said you can't do that. A case called Crawford v. Washington. It says, hey, you have to have the witness come to court. If you can't have the witness come to court, you have to have some other evidence, third-party witnesses observed it. You can't have hearsay evidence, multiple layers being said. Who did that? Who protected the Constitution? A guy up in Washington State who was doing the appellate brief and kept making the argument. And Crawford was decided. Justice Scalia wrote the opinion saying the Constitution says what it says. You have a right to confront witnesses. Doesn't mean says you confront witnesses that weren't a party or weren't actually there at the time. You have to actually bring the person there. Okay? Why do you think homicides are tough? Why do you think they are that way? It's because you have to bring in other evidence to show that it's being done. Okay? You don't like, there's no such thing as a technicality. Okay, it's called due process. Somebody didn't follow the process. You don't like the way the statute was poorly written. Guess what? Go thank your local legislator out there, okay? Whether it be Congress at the federal level or the state houses in the local state, okay? Some of these legislators, if you ever talk to them, can barely spell legislator, but yet they're the ones that they're drafting laws, okay? And it happens many, many times here. I can tell you in Colorado, I've seen it just last 2 years, I think. They drafted laws. They go through all these committees and back and forth to both houses and sign together. And someone managed to read it, and they forgot to put really the whole thing that why they passed the law. It was a funding deal. And so people don't read this stuff. They draft it and say, ooh, wouldn't this be nice? This is kind of the knee-jerk reaction, political kindness thing of the day. And they don't read it. And then it goes and it's on the books and it's on the law because it's politically expedient, it's politically nice. And then some guy like me reads it and says, what the hell does this mean? And then some judge says, what the hell does this mean? I can't enforce this. It doesn't put anybody in notice as to what really the crime is. And so the remedy is not to say, oh, the judge messed up. Oh, the criminal guy and his, high-paid lawyer got him off because the statute wasn't clear. Go talk to the legislator. Go talk to the legislator that, is there for his 90 days, or whether it's a full-time job, like in some states, I think in California, where they just mass produce these laws and crank it out. And then there's challenges to it because they're so inartfully drafted. That's the problem. And they never call the defense bar to ask, hey, how could you help us tighten up this thing, this law that we want to pass so that you can do it? Very, very rarely does that ever happen. Okay? So I get it. Nobody likes the bad guy to go free, and nobody wants to say, oh, make it look like they're supporting the guy that did, or woman that did a bad thing. But that's our process, and that's our constitutional law. And I am not going to apologize, nor will I ever, for doing my job as a lawyer. And frankly, any lawyer that says I can't take that particular case, I got a real problem with that. Okay, why'd you go to law school? Why'd you go to law school? I can't imagine somebody grew up and said, you know what? I cannot wait to go to law school because I want to do corporate transactional work. Most of the people in law school, well, I was maybe a little opposite. I was like, hey, I'm doing corporate. This is great. I'm going to do it. Then I got bored, okay? And I loved doing trial work. And then they said, hey, you're never going to go do trial work for probably 5-6 years until you get out there, just because that's the way it was at the time. And I'm like, I want to go do stuff. So the Marine Corps was like, hey, come on back. We'll have you doing trials. And I showed up my duty station, I had 3 trials the second week I was there. It was fabulous. I've been doing them ever since. But nobody grew up and said, boy, I want to go make sure if that comma's in the right spot and do, mergers and acquisitions. Some people, maybe that's what they're doing. I just can't imagine that. Most of the people I went to law school with were usually pretty idealistic, and they wanted to change the world, and then reality hits in, and, they're all driving BMWs and Mercedes these days. And for lack of a better term, we're, doing the corporate transactional thing. Very few, I guess, could say that they were true to their ideals of trying to save the world and make a better place. I just want to defend the Constitution. Okay, that's my mission, to make sure everybody gets a fair trial. Okay, and so I don't know if you all remember. There's a great movie, A Few Good Men. Jack Nicholson, Tom Cruise, and that he gives that great speech. And maybe if the editor guy can do a great job, he can throw up that little scene where Jack Nicholson says, you can't handle the truth. I found that transcription and I've changed it a little bit, okay? So the next time somebody says, how can you represent somebody? You just remember this. Son, we live in a world that has a constitution, and that constitution has to be guarded by men with litigation skills. Who's going to do it? You? I have a greater responsibility than you could possibly fathom. You weep for victims and you curse the defense attorneys. You have that luxury. You have the luxury of not knowing what I know. That acquittals for murders, while tragic, probably saved lives and protect freedom. And my existence, while grotesque and incomprehensible to you, saves lives and freedom. You don't want the truth because deep down in places, you don't talk about it at parties. You want me defending that case. You need me on that case. We use words like reasonable doubt, burden of proof, due process. We use these words as the backbone of a life spent defending something. You use them as the punchline. I have neither the time nor the inclination to explain myself to a man who rises and sleeps under the blanket of the very freedom that I provide, and then question the manner in which I provide it. I would rather you just say, thank you, and went on your way. Otherwise, I suggest you pick up the Constitution and stand for liberty. Either way, I don't give a damn what you think.